Okay, let's dive in. We've got quite a stack of sources here. Court docs, legal analysis, news, even a market chat from Reddit.
Mm-hmm.
And it all circles around this pretty big Supreme Court move, something that could really reshape how parts of the U.S. government work, maybe even impact the economy.
Yeah, we're talking about the Supreme Court's recent stay order in Trump v. Wilcox. And it's fascinating because it connects directly to this, foundational legal idea that's been around for almost a century.
Exactly. So our mission today really is to cut through all the noise and the complexity.
Right. Pull out the key bits from the ruling, the dissents, what the legal evils are saying, and just try to understand what's actually happening and why this interim decision is causing such a stir.
Because it's not just some obscure legal point, is it? This really gets to the heart of presidential power versus, well, the independence of these key agencies.
Agencies that handle things like labor law, federal jobs, consumer protection, maybe even, keeping the financial system stable. It's this fundamental tension we need to explore.
Okay, so where do we start? Maybe with the idea of these independent agencies themselves.
Good place. So Congress set up bodies like the National Labor Relations Board, the NLRB, or the Merit Systems Protection Board, the MSPB. The whole idea was to have agencies with specific expertise handle complicated stuff, ideally with some breathing room from direct political control.
Right. They're often set up differently, like multi-member boards, bipartisan members.
Yeah.
The thinking being that experts from both sides, if they aren't worried about getting fired just because the president disagrees with them, can make better long-term calls.
And the legal bedrock for that independence, it goes way, way back to 1935. Humphrey's Executor v. United States.
Humphreys, that's the classic one, right? President Roosevelt, FDR, wanted to fire a guy from the Federal Trade Commission, William Humphreys.
Yeah, and not because Humphrey was incompetent or anything. FDR was just blunt about it. Their minds didn't go along together on policies. They just disagreed.
And the Supreme Court back then, what did they say?
A huge ruling. They basically said, yes, Congress can create these bodies that act a bit like legislatures or courts. They called them quasi-legislative or quasi-judicial. And Congress can limit the president's power to fire members, saying it has to be for cause, like, neglect of duty or actual misconduct.
And they explicitly said that didn't violate the president's executive power.
Exactly. They rejected that argument. And this wasn't a one-off. It was reaffirmed later, Weiner v. United States in 1958. So this principle that certain independent agency heads have job protection from purely political firings, that's been settled law for, 90 years now?
Okay. Settled law for 90 years, which brings us right up to today's dispute.
Precisely. President Trump removed Gwynne Wilcox from the NLRB and Cathy Harris from the MSPB. And importantly, the sources all agree these firings were not for cause. It was acknowledged they weren't fired for inefficiency or anything like that.
But the laws setting up these agencies, they seem pretty specific on this point.
They do. The statute for the NLRB says members can only be removed for neglect of duty or malfeasance. And for the MSPB, it's inefficiency, neglect of duty, or malfeasance. Pretty clear for cause language.
So Wilcox and Harris sued. Makes sense, arguing the firings broke those laws.
Yep. And then began the legal back and forth. District courts in D.C. sided with them first, said reinstate them.
All right.
Then a 3-judge panel on the D.C. Circuit Appeals Court paused those orders, basically letting the firings stand for a bit.
But that wasn't the end of it.
No, because the full D.C. Circuit Court, what they call sitting on bonk, all the judges together, they took another look. And they reversed the panel, reinstated Wilcox and Harris again, and they were very clear. Lower courts have to follow Supreme Court precedent, meaning they have to follow Humphreys.
Meanwhile, what's the administration's argument through all this?
Their core claim is that these laws themselves, the ones limiting the president's removal power, are unconstitutional. Solicitor General Sauer argued the Constitution gives the president really broad power to remove executive officers.
And that the NLRB and MSPB aren't covered by Humphreys.
Right. They argue these agencies wield substantial executive power and therefore fall outside any sort of Humphreys exception. And they explicitly said they plan to ask the Supreme Court to just overrule Humphreys entirely once the case got there for a full briefing.
Which leads us right to the Supreme Court's move on May 22nd, 2025. They granted the administration's request for a stay.
Right, a stay. And we need to be really clear what that means and what it doesn't mean.
Okay.
It's a pause. a temporary halt. The court hasn't decided the big questions yet, whether the firings were ultimately legal, whether Humphreys is good law or not. It just freezes the lower court's reinstatement order for now.
So Wilcox and Harris remain out of their jobs while the whole appeal process plays out.
Exactly, while it continues in the D.C. Circuit and then potentially up to the Supreme Court for a final decision on the merits, the actual substance of the case.
And how long does this stay last?
It stays in place while the appeal is pending in the D.C. Circuit, and then while the Supreme Court decides whether to even take the case that's called granting certiorari. If they decide not to take the case right now, the stay lifts automatically. Or if they do take the case, it lasts until they issue their final judgment.
Okay, so why did the majority grant this temporary pause? What reasons did they give in that unsigned order?
Well, they hit a few points. First, they pointed to Article 2 of the Constitution, the executive power vested in the president. They said the president generally can remove executive officers without cause.
But they added a caveat.
Yes, subject to narrow exceptions recognized by our precedents. Interestingly, they cited some recent cases like SELA law there, but didn't explicitly name Humphreys in that specific sentence.
What else?
They made a kind of preliminary judgment. They said the government is likely to show that both the NLRB and MSPB exercise considerable executive power.
But they didn't decide that definitively.
No, they were careful. They added, "We do not ultimately decide in this posture whether the NLRB or MSPB falls within such a recognized exception. That question is better left for resolution after full briefing and argument." So, keeping their powder dry on the final call.
Okay, and the balance of harms that usually comes up in stays.
It did. They argued the balance tipped toward the government. They felt the government faced a greater risk of harm from an order allowing a removed officer to continue exercising the executive power compared to the harm the wrongfully removed officer faces from being unable to perform her statutory duty. Basically, they weighed the potential disruption differently.
And the last point was about disruption itself.
Yeah, they said the stay helps avoid the disrupting effect of the repeated removal and reinstatement of officers while a case is ongoing, trying to create some stability, I guess, during the litigation.
But there was a strong disagreement on this.
Yeah.
Justice Kagan wrote a dissent.
A very sharp dissent, yeah. Joined by Justices Sotomayor and Jackson. And her core point is simple. Humphrey's executor is not just old, it's good law. It's been the foundation for independent agencies for 90 years.
And she thinks the NLRB and MSPB fit right into that Humphreys model.
Absolutely. Multi-member boards, bipartisan, doing quasi-legislative or quasi-judicial work, just like the FTC back in 1935. She sees them as squarely covered by the precedent.
So what was her criticism of the majority's action?
Well, first, she really takes issue with using the emergency docket, what some people call the shadow docket for this. She argues the stay effectively blesses the president's firings that everyone admits were without cause and violated the statutes.
Right.
And she says the emergency docket shouldn't be used to, quote, overrule or revise existing law, especially a major long-standing precedent like Humphreys. That should happen after full argument and deliberation.
She also seemed to think the lower courts did the right thing.
Yeah, she points out the D.C. Circuit was just following Humphreys, which is exactly what lower courts are supposed to do. So she argues, by issuing the stay, the Supreme Court is basically letting the president ignore precedent, letting him overrule Humphreys by fiat, at least for now.
And the balance of harms argument. She disagreed there, too.
Strongly. She says the majority misidentified the interest on the official side. It's not just their jobs, it's Congress's and, more broadly, the public's interest in having these agencies function independently, like Congress intended.
So the public interest in having experts make decisions without political pressure from the White House.
Exactly. She thinks Congress's will, written in the law, and the basic idea that laws are presumed constitutional, those should have weighed much more heavily.
And what about the president's interest?
She called the majority's view on that distorted and overstated. She says it's the president's interest, not necessarily the government's interest, because Congress clearly had a different interest here, and she makes the point. 14 presidents managed fine with these rules. Why the sudden crying need to fire these specific people now?
Implying.
She suggests it shows an impatience for predetermined outcome, basically implying the court is already leaning towards overturning Humphreys, and that Humphreys itself is being treated as the emergency here.
Wow. And the disruption point. The majority said the stay avoids disruption.
Kagan flips that. She says, wait, the lower court reinstated them, so the Supreme Court's order removing them again causes the disruption, unless, she adds pointedly, that order presumes or implies that they will be re-removed next term anyway, again suggesting the fix might be in.
She even brought up the Federalist Papers.
Yeah, Federalist number 78. The bit about courts needing to be bound down by strict rules and precedents to avoid arbitrary discretion. Her implication is the majority, especially using the fast-track emergency docket, wasn't being bound by precedent here, but was favoring the president's immediate wishes.
Okay, this is getting really complex, but then there's this whole other piece about the Federal Reserve.
Right. This was kind of a curveball in the majority opinion. They just dropped in this sentence saying the case has no bearing on the constitutionality of for-cause removal protections for the Fed board members or the FOMC.
Which seems odd, to just single out the Fed. How do they justify that?
They describe the Fed as uniquely structured, a quasi-private entity with a distinct history tracing back to the first and second banks of the United States. They cited a footnote from the Sela Law case.
And what did the dissent make of that? Justice Kagan found it puzzling.
Extremely puzzling. She called the Fed mention out of the blue. Her argument is, look, the Fed's independence rests on the same legal and analytical foundations as all these other agencies, basically. It relies largely on Humphreys.
So if Humphreys is potentially on the chopping block for the NLRB, it should logically affect the Fed too.
That's her point. For the majority to say no bearing, they have to create, in her words, a different story, a bespoke Federal Reserve exception.
And the footnote they cited.
She digs into that too. She points out the footnote in Sela Law wasn't stating a rule. It was actually part of rejecting an argument made in a dissent in that earlier case. It was more like assuming something for the sake of argument. So turning that into a reason to carve out the Fed now, she argues, is basically making new law on the fly, again, on the emergency docket.
So why might they do that? Just speculate a bit based on the context.
Well, one line of thinking, which you see hinted at, is about the markets. You know, the Fed's independence is seen as crucial for economic stability. Maybe there was concern that if this ruling seemed to threaten the Fed too, it could really rattle financial markets.
Especially given President Trump's past comments about wanting to fire Fed Chair Powell.
Exactly. So perhaps this was an attempt to signal to the markets, don't worry, this case isn't about the Fed, its structure is different. A way to insulate it from the immediate fallout.
Okay, setting aside the legal theory for a second, what's the immediate practical impact of this stay?
Yeah.
Especially on the NLRB.
It's pretty significant, actually. One of the legal analyses we looked at from Ogletree-Deakins points out that with Gwynne Wilcox remaining off the board because of the stay, the NLRB now lacks the quorum required to issue decisions.
A quorum being the minimum number of members needed to do business.
Right. They don't have enough voting members to make official rulings.
And the effect of that?
It basically paralyzes the agency. It's hampering its ability to revise or reverse recent decisions, particularly some seen as employee-friendly from the previous administration. And more fundamentally, it just halts the NLRB's main job, adjudicating labor relations disputes. Cases just can't move forward.
And how long could that last?
Well, according to the analysis, this lack of a quorum is expected to continue until either new board members are nominated and confirmed by the Senate, or if the stay eventually gets lifted and Wilcox returns. But for the foreseeable future, while this case works its way through the courts, the NLRB is essentially sidelined.
Okay, so this specific case is having real-world effects right now. But it also seems to fit into a bigger picture, doesn't it? A wider trend involving these administrative agencies.
Absolutely. You can't really look at this in a vacuum. The step-toe analysis we saw mentions an overwhelming trend to restrain regulatory agencies' power. This case feels like part of that larger movement.
We've seen other Supreme Court decisions pointing this way recently, right?
Definitely. Think about the court overturning Chevron deference. That was a huge deal. For decades, courts generally deferred to agencies' reasonable interpretations of ambiguous laws. That's largely gone now.
There were also changes to how people can challenge agency actions under the Administrative Procedure Act.
Right, and specific agency challenges, too. CELA law, which we mentioned, struck down the structure of the Consumer Financial Protection Bureau, making its single director removable at will by the president. That's different from these multi-member boards, but still part of the trend.
And SEC v. Jarkissi.
Yeah, that limited the SEC's power to use its own internal administrative law judges for certain penalty cases, saying defendants have a right to a jury trial in federal court, another check on agency power.
And it's not just court cases targeting these structures.
No. The FTC's structure is also being challenged, and perhaps even more striking. The Department of Justice itself, the executive branch, formally stated back in February 2025 that it believes the FTC commissioner's job protections are unconstitutional. They've basically announced they want the Supreme Court to overturn Humphreys regarding the FTC.
Even within the FTC, there was that statement from the chairman about the agency's own internal judges.
Right. Chairman Ferguson agreed in a separate statement related to the H&R Block case that the tenure protections for the FTC's administrative law judges were unconstitutional. So challenges coming from multiple directions.
So putting it all together, some observers, like TPM, and we're just reporting their view here, see this whole pattern as pushing towards what they call a more unitary executive.
Which means?
The idea that the entire executive branch should operate essentially as a direct extension of the president's will, with very few independent power centers or institutional checks like these independent agencies. A view sometimes associated with plans like Project 2025, fewer guardrails, more direct presidential control.
Okay, that's a lot on the legal and political side. But you mentioned a Reddit thread, too. What was the context there? More about the economy.
Yeah, it was interesting context. It was a discussion among traders, mostly about the market environment. Lots of talk about market optimism, rallies, even forecasts of S&P 7,000 by 2027.
What was driving that optimism, according to them?
Things like signs of improvement in talks with China, capital flowing in from the Middle East, and the potential impact of proposed tax relief measures. General positive sentiment.
But it wasn't all rosy. Were there cautionary notes?
Oh, yeah, definitely. Concerns about those tax cuts stalling or potentially expiring in 2026, which could act like a stealth tax hike just as government debt costs are rising.
Makes sense. What else?
Credit markets reacting to things like the Moody's downgrade, meaning higher borrowing costs for the government via treasury yields, worries about unpredictable trade policy potentially hurting consumers and GDP, and the point that even if foreign money is coming in, it might just be funding deficit spending, which isn't sustainable forever.
So, a typical trader discussion, seeing opportunities but also risks. What was the bottom line perspective?
Kind of summed up as, the rally is tradable, you can make money off the short-term moves, but maybe not structurally sound. Like some were expecting a downturn eventually and stress, just playing the charts, not getting caught up in personal biases about the economy.
Yeah.
So how does that connect back to the Supreme Court case? It's not like traders are glued to C-SPAN watching oral arguments.
Right. It's not a direct driver day to day. But the connection is this. The Supreme Court case is happening against this backdrop of potentially massive shifts in government policy and structure. We're talking about fiscal policy, trade policy, and fundamentally how the government itself is run the power of the president, the independence of agencies.
And the stability of those agencies, especially the Fed, which the court specifically mentioned, that is something markets care about, right?
Absolutely. The independence of the Federal Reserve is a cornerstone assumption for many market participants. So while this specific case might not directly target the Fed, according to the majority, the underlying questions about presidential power and agency independence create a level of uncertainty. Potential changes to how these crucial economic institutions are governed that introduces risk, and markets definitely pay attention to risk and uncertainty.
Okay, so let's try and wrap this up, summing up the core situation here. The Supreme Court's stay in Trump v. Wilcox, it's a temporary measure.
Right. Keeps Wilcox and Harris out of their jobs, for now, jobs they were fired from without cause, even though laws seem to protect them. It pauses things while the bigger legal fight over those firings continues.
But even though it's temporary, it feels really significant.
Oh, hugely significant. It's potentially a major turning point for that 90-year-old precedent, Humphreys executor, and the whole idea of independent federal agencies. It throws into sharp relief this fundamental disagreement about the balance of power. How much control does the president have versus Congress's ability to design parts of the government to be insulated from direct political firing?
And the next step is likely back to the Supreme Court for a final decision on the actual merits.
Almost certainly. And that final decision, whenever it comes, could really reshape the landscape of presidential power and the administrative state for a long, long time.
So the final thought for you listening. What does all this mean on a practical level?
Yeah, think about it. What if a president could remove the heads of agencies regulating labor or consumer protection or even financial markets just because they disagree on policy? How would that change the way those agencies operate day to day? Who would they feel more accountable to, the long-term public interest as defined by Congress or the short-term policy goals of the White House? What does this case and the broader trends we've talked about really suggest about where federal governance might be heading?